So welcome to this seminar, and on Terroir and Innovation Food Law I will very briefly introduce you the speakers. We are very delighted and honored to have both of them here. The first speaker will be Professor Pierre-Emmanuel Moïse, who is the director of the Center for Intellectual Property Policies at McGill University, and he is an expert on IP, copyright in particular, and in property law. And so he will bring some experience from the other side of the Atlantic Ocean, and will speak about the emerging issues concerning the protection of terroir and geographical indication in Canada. And the other speaker will be Professor Ferdinando Albisini, who is professor of agricultural law at the University of Latouche, so in Viterbo. He's an expert in general in food law in many different areas of food law, and with specifically regard to geographic indication, he has written a lot about them, and very interesting pieces of literature about protecting and conceiving, I would say, more in general, geographic indication the right way. So I don't want to lose much more time, and I will give the floor to Professor Moïse. Only one practical aspect. We have organized with two brief presentations, the first one by Professor Moïse and then one by Professor Albisini, but we really hope that to be able to engage in some discussion with you, so the presentation will be short, and I hope that speaking English will not make you shy, and will take part to our seminar in an active way. So thanks again to both the speakers for being here.
Thank you, Matteo. It's a pleasure to be in Trento again. It's take me as an evidence of a long friendship between Trento and McGill. It seems to be almost like a direct connection, a flight or a secret tunnel, like in Harry Potter. I come here and meet my colleagues here, and there's one who is actually speaking in the other room. So it is really an important connection for us, Trento, and I'm very happy. And in fact, I owe it to Matteo when he came to McGill to do his postdoc, who triggered the interest into food law. And take me also as an evidence as you can always change or take another trajectory in your life. I'm more of a high-tech person, and for some reasons I felt like I needed a change, and food law was here, and just for me to collect, and Matteo was put on my way, and this is how I became not an expert, but someone interested in geographical indication. So I feel slightly like an imposter, although I do have committed a number of articles in geographical indication, and I'm not too sure whether I'm interested more into the food itself or into the legal aspect of food. It's another matter for another discussion. I've decided to get something slightly original coming from Canada. It's terroir and innovation, and I took it as really as a plan. First terroir, then innovation, and a few ideas. And so I take you with me to Canada, this beautiful country. I'm French originally. I moved there 25 years ago. Canada gave me a fantastic position, a wife and two kids. So it is really it has become my country. As you know, within Canada, we're in Quebec. We are in the federal system. So part of it is jurisdiction of the federal government, and the provinces do retain a wide range of jurisdictions. And there's a vacuum concerning geographical indication. We're not too sure where it falls, and Quebec was heavily influenced by France. As you know, we have, because of the colonial history and the attachment to France. So in 1996, Quebec realized a real coup by adopting what is, until today, the first law on geographical indication. It was pretty much a copy of the French legislation, and the idea was really to transplant. It was interesting because in the mind of the legislators, just adopting a regulation would spur and incentivize producers to actually register geographical indication. And it didn't happen like this. It didn't work. So 1996 was the first iteration of geographical indication, but in fact, although it was seen at the time as a real innovation in Canada and almost an act of resistance vis-à-vis the federal government, who was dragging behind. There was no national agricultural policy. Quebec had barely an agricultural policy. We'll come back to it. So we just transplanted what seemed to be working in Europe, and we let it lead in Quebec, but nothing really happened. It was the reason why is that there was no culture of geographical indication. So law is not just about textual legislation as we know it. There was no culture. There was no understanding. Producers knew what was going on in Europe, but they felt very shy about calling it a name, calling it or attributing or assigning a specialty to a particular product. They were quite shy and quite humble vis-à-vis the products that they would actually grow or make. So they would not call it as a traditional product or as a specialty product, because they didn't have the history. They didn't have the evolution, the time for a product to evolve as being owned by people and that product that would be part of a terroir. Another reason why it was seen in 1996 as the coup is because we had until 1996 the federal system with the certification mark. Certification mark was very well known. Certification mark is it's a type of private trademark. There is one owner. The state is not involved in it. It's just an association that is managing the trademark. So there was no involvement of the state, but producers knew about certification mark, but they didn't really know about the geographical indication. An interesting point, it is actually the UK, the United Kingdom, that forced the introduction of Section 7B of the Paris Convention, which introduced the collective trademark. Because at the time, the United Kingdom had the certification mark, mostly used by unions. And so it's an interesting irony that in fact it was the system, the common law system, who forced the introduction of a collective trademark, but did not follow suit after that. They did not really engage into a type of collective trademark that is geographical indication. So bottom line, 1996 was a failure. There was no application, and only one geographical indication, or one collective trademark, which was the biologique, which was registered. So there was a report, and we made sort of a mea culpa. We looked at what was going on at the time, why it did not pick up, and there are many reasons. Only three, very briefly. Legislation was not accessible. Again, there was no culture. The legal transplant didn't work as we had expected. lack of support resources for producers. They were small size productions, and they were not well equipped to understand the law. Poor communication and definitional problems. So when I said definitional problem, this is the part one, terroir. Everybody at the time started to speak about terroir, but for the producer, it was very difficult to imagine what terroir was. Just putting a name on a product, putting a name on a know-how, putting a name on a particular practice, and calling it ours, like in a collective movement, was something that has never been envisioned by producers in Quebec. And again, they felt quite shy about calling it a specialty product when they had very little history. That was again, it was a new land, a new country, new France, we call it. So we had a couple of reports on working on the definition. We had to go back from scratch and explain to producers what is terroir, what we really wanted to protect. And all the reports and the studies that were produced at the time, that were published, revolved around the notion of terroir. And again, there was a miscommunication. So terroir was aligned with the notion of culture and history, and it did not pick up. It simply, there was a communication problem. Producers did not see themselves in Quebec, didn't see themselves into this cultural, historical aspect of geographical indication. 2006, we revised completely the legislation. They said it's enough. We're going to move away from the notion of terroir, which has no meaning. It has no meaning. So we will focus on quality, on identifying products that are original, authentic, genuine, and that could be distinguished from other products. So we changed the rhetoric at the time. The discourse changed, and it became slightly more successful. To 2006, we had more tractions. Producers started to see and realize there was a communication with their European colleagues, Italian, French delegations who came to Quebec, explained to Quebec producers what really it meant and what are the processes to obtain a geographical indication and the benefits. And slowly it grew within the producers' mindset. So 2006, not only we revised, we moved away from the definition of terroir with no definition, and we created a body that we call the Conseil des Appellations Réservées. It's a board that would homologate geographical indication. So it became slightly more successful. We worked, Matteo was in Montreal for a conference on cider. Cider is the last chapter of a successful story now where in Quebec we do protect geographical indications, and we have ice cider of Quebec. It is a very unique product, and you need cold temperature, as you can imagine, to have ice cider. It's a very fine product, and it's working. But I'm just gonna show you the complex or in fact how producers see themselves. So this is part of the norms that have been homologated by Quebec, and you see that they explicitly mentioned that the ice cider was a new product. It was actually created by French, who was playing with apples in 1989, and he was inspired by ice wine, which was already in existence, but 1989. So it's yesterday. So you cannot have this notion of terroir tied to a particular idea of history or culture, right? It's a new product. It's an innovative product. So you see, that was part of the norms that have been approved by the Quebec minister. It can hardly be supported by historical evidence. So we moved away from the notion of terroir, moved away from any relation with history and culture. That being said, something has changed since 2014, and we have had more geographical indication. Understand me well, we are only at the 7th or 8th geographical indications. We're still slowly improving the numbers, but it's not at the magnitude of what we have in Europe, in France, and Italy. But there is a realization now. There's a movement now for having a real agricultural policy. So last week, our Prime Minister, Minister of Quebec, Couillard, announced a vast investment in bio-food and a vast movement into specialty products in Quebec. We're talking big numbers, almost 5 billion over 7 years. So it has been now a focus. It's quite late in the game. You in Italy and in France have been into this type of price discrimination more actively. But now is the time, now the stars are aligned, and we are investing in Quebec in this type of discrimination and quality assessment programs. So 5 billion in biofood over 7 years, territorial planification and zoning. So innovation, I know that will be my second part quickly. Innovation for us is not only tied to geographical indication, which is again fairly new, but it is also tied to what we call the smart zoning. So property law, smart zoning is part of the overall intelligence about products, about new types of farming and new ways of exploiting the land. Second part, quickly, innovation. And here you will hear a story that you probably never heard before. The landscape in Canada, and the political landscape, forces me to talk a little bit about what we call the reconciliation. Reconciliation is a political endeavor to repair or creating a bridge with the First Nations that have been left, and there's terrible stories how the colonialisms have treated who we call the Indians, but the First Nations, and the real effort to bring back First Nations and First Nation culture. As a matter of fact, many of the recipes, many of the way the food that are traditional in Quebec are in fact being created or discovered or used by First Nations. Now the real challenge for us is how do you use a Western system to promote First Nation productions and creations, and that's a real challenge. So I'm taking you quickly to virtually meet Christian Coucou. He's the person whom we work with at McGill. He's the representative of a Atikamekw nation. And we had several discussions and a project at McGill to use the Quebec legislation on geographical indication to try to find one product in particular and see whether the Quebec system will be fit to protect and develop a particular product and heritage of a First Nation. So we met a couple of times and we explained, and there was a lot of listening on their part, but not too much intervention. And I was wondering what was wrong. But they kept on coming, and we met, and and they were very suspicious. So they did not disclose any particular recipe. I was asking, do you think that there is one particular product, a traditional product that could be protected under the Quebec system? there was no real answer. They wanted to hear more about what the system, the Quebec system, was doing. And then after a certain while, trust became more front and center. They trusted us a little bit. And Christian Coucou said two things. Well, we probably have products. We probably have many of our recipes are used now in Quebec traditional, what they call Quebec traditional culinary culture. They have borrowed most of our recipes. But we also have, if I want to point to one particular product, what we call the pâte de bleuet, or they call it the blueberry sauce, which is made out of wild berries. They're picked at a certain time during the year and with a particular process. And he said another thing. He said, before going further, you will have to come to visit us. So I don't know if you see where it is. It's almost 6 hours just driving. The reason why I mention that is because it's a bottom-up process, geographical indication. You have to have a community. You have to have a sense of collectivity. Then you cannot invent. You cannot invent a product and start to claim any particular name. First, you have to agree on a name. There are many families, many clans that are part of the same tribe, and each clan call it a different name. So you have to reach a consensus first. Then you have to agree on a particular recipe, and you have to convince them that in the norms it will be a certain amount of disclosure. It would be a public document. Then you have to obtain a consensus and sit all the clans together and make sure that they would agree, right? Then a bigger question: who owns my name? A name for First Nation is not a sign. It's something that goes far deeper, that is rooted in their own culture. It's rooted into nature. You cannot extract nature, and a name is part of a tree. It's part of the earth. It is a nonsense for them to just even start talking about ownership, property, and then the bigger and front and central question: how do you explain that in fact it's going to be the state of Quebec, the imperialist state, who will be in charge of protecting your name? Because although there is no clear state ownership over a geographical indication, it will be up to the state to protect and make sure that the homologation process, the certification process, is followed. So to conclude, there's a lot to say about this. To conclude is that we realize that any effort to develop a geographical indication for First Nations will need a lot of listening. We'll need to go back to see them, not just them to seek information, but we will need to go and listen far more to be able to assess whether the Western system could fit and could be used to develop a particular protection. And the last point is where I just suddenly realized how smart they were. They came again and again, despite the fact that I really felt that they were suspicious about the whole scheme of having a name, their name, of a very cultural, important part of their culture, so being branded and used through and processed through the Western system, right, with the state of Quebec as a guardian of their geographical indication. So they were very suspicious. And I realized at the very end of our meetings why they would be eventually ready to go this route. And it came as one question. Christian Coucou was sitting at the last of our last meeting, and he took me apart and said, do you think that geographical indication system could help us in land claims? I suddenly realized that, in fact, as soon as you delineate and use a geographical indication to identify the place where a product can be made, it can eventually be used to protect lands in the midst of land claims and fights against forestry industry and the use and exploitation of forest and land on their territories. So that was the only reason at the end. That was so there is now discussions about using geographical indication as a way to protect and to assert land claim for First Nations. So that was, and I think it is highly innovative, and this is something that I didn't think between meeting them. So there's a lot more to say. I just brought you with me to Canada and to this beautiful place in northern Quebec, but I will let my colleague entertain you with his story. Thank you.
We can have a presentation by Professor Albisini, and then we have some discussion.
We can change. Yeah.
Trying to bridge together the two talks and have some common discussion.
So first of all, I just want to thank everybody here, and of course our good friends and colleagues, Umberto Izzo, Matteo Ferrari, but especially the French or Quebecese or Canadian colleague. And you know, I prepared some slides, and I will pass through very fast within the slides. But I was really deeply impressed by your conclusion when we were speaking about the connection between the land ownership, I don't know, the land use, and geographical indication. Because you can just substitute one word, First Nation, with European farmers, and you will find that the approach was really very similar. And that was the idea. Then we have more than 30 years of experience on these topics, and nowadays we are starting, I will try really fast to give just a few points to discuss, starting to think also in terms of intellectual property. But the beginning was quite different. The beginning was common agricultural policy. So going back to the question, and I think my voice is high, but all the three words that our friend chose forced me to think, which is always a very interesting task. But terroir and innovation in food law. Terroir. What do we mean? What do we speak about? What do we talk about when we talk about terroir? We are speaking in French about espace rural, which is a definition which you have in your Code Rural, or are we thinking about the pays which is defined in the Code Rural, because the French worked a lot on this idea of rurality, which is quite different from the area of agricultural activity in the Italian law. Or are we thinking to the old Roman territorium urbis? And terroir is a word which is coming from territorium, but territorium is part of an idea that the center is the town. And in fact, if you think, there are many cases we discussed already a couple of years here in Trento on the idea of terroir, but terroir comes from towns. And usually when you think about prosciutto di Parma, And when you think about any other sort of things, usually you have a town, because it is the town, it is the territorium. And going back from that, but what about innovation? Are we thinking about scientific innovation? Because you were speaking, and I was listening with great interest, to this new technique of ice, cider, and so on. So this is scientific innovation. Or are we thinking about legal innovation? And legal innovation as an answer to the scientific innovation, as a reaction, as we had in many cases regarding food safety, like BSE and so on, or we were just speaking a few minutes ago with Umberto about proactive innovation, an innovation which is coming within the legal reasoning. And I was really delighted by your experience with these groups of First Nation, because you were just in some way showing how even lawyers, I think this is interesting for our young students, lawyers may be innovators. Lawyers may use paradigms, categories, theories to give some tools, some very new tools, which give a very new way to go on problems. So, for example, regarding the use of land. And then, what about tradition? This is the most difficult word, tradition. What we intend for tradition. Is tradition reproducing something or creating something? Is tradition something, as Professor Hobson wrote, I discovered when I read the first time the famous book of this famous British historian, that the Scottish kilt is not a tradition, it's just an invention. It has been created. And also an Italian, Corrado Barberis, who studied a lot regarding the rural tradition, and he said, tradition is a successful innovation. And I think everybody, you know the very good wine which is made in Tuscany, which is the Chianti Classico. Until 100 years ago, there was no wine in Tuscany. It has been imported as an innovation by a significant politician, which was also an innovator. Nowadays, when we speak about tradition, we speak about that. So, and within this very general framework, what happens? What is the result of globalization? You were speaking, I found really, I must thank you, really, I listened to you with great interest, because you were speaking about legal transplants. You were speaking about this using, which is of course easy for Quebec, which has a code civil à la française, but it was importing from France. But in fact, in Europe, we imported our first regulation on PDO and PGI from the model, the French model, because even in Italy we didn't have. But today, what is going on with globalization? Because just to go back to one of the points that you said at the end, which is a very significant one, who is the owner of a PDO or PGI? According to our doctrine in Europe, there is no ownership in the civilian sense. But on the other side, there has been an agreement stipulated between the Italian Office Anti-Fraud of the Ministry of Agriculture with the largest organization in China for selling products. And they had to declare themselves as the owner of the PDO, Prosecco, Chianti Classico, and so on. Because the idea in this quite different country, which is China, is that it is not possible to have anything without an owner. While when we are speaking about PDO and PGI, we have a very nice example of what is, in most cases, named as common goods. This is a typical case, which was, of course, a typical case of First Nations, which didn't know the modern idea of private property. So we must start, and especially you students in this course, to think differently between ownership and property, and even the word property is not an appropriate word in English, but if we speak in Italian about proprietà is a full right, while ownership are all the different ways of falsea and so on to own something. And this is the case. So the point is, when we look to the law, especially when we are very young, we have this idea of law which are something which is on the walls, which is stopped there. And we have to consider law, in my idea today, legal rules, as bricks. We are building something. We must have the arrogance to say that lawyers are architects. I would like to be an architect. I am not able to be. I have no artistic temperament. But lawyers are architects, and so not stones that we have on our path, but bricks which we are building something. So what about when we speak about food law? A distinguished U.S. scholar wrote something which I was really interested to. He said that when people decide what to eat, they decide based on a rough negotiation between three factors: identity, convenience, and responsibility. And what is identity? Because we were speaking a lot about identity. Of course, identity of European farmers, identity of producers, identity of all population of the Canada region. And so in identity, many other things work together, things which in some cases are not material things. So we speak about quality of goods, but usually we give to the term quality a meaning which is a material quality, something that we can see and write there on an objective quality. While when we speak about pleasure, creativity, cultural values, we are just understanding that in food there is much more. And so food comprises many indicators, and extrinsic quality include brand name, price, and counterage. So let me give you just a couple of examples regarding origin, because when we speak about origin, we always think in terms of small production related to a specific territory. But look to this advertising from Coca-Cola. Here says Coca-Cola is more Italian than you imagine. Coca-Cola, which is the famous, is the first brand which you find equal in your idea wherever you go, from Zimbabwe to Mozambique to China to South America. And Coca-Cola. But a second point, and this is also a matter of responsibility. We had a problem in Europe, say 3 or 4 years ago, with the production of Coca-Cola. They had problem of food safety with Coca-Cola produced in Belgium. You know, I must declare, I am chauvinistic. I think that we Italians have an enormous lot of defects, but leave aside for food safety, because we give so much importance to the quality of food that the level of food safety control in Italy is the best of the world. I can give you even evidence if you want to know this. So in that case, there was a problem with the production of Coca-Cola in Belgium. The Coca-Cola company bought a lot of advertising in big newspapers saying all the Coca-Cola sold in Italy is made in Italy. This is not a formal guarantee. This has nothing to do with the receipt. This is just a matter of identity. Second, another case, Zaccagnini. This is a producer, a significant producer of wine in a region of central Italy, which is Abruzzi. And this is not wine PDO or PGI. This is wine named Zaccagnini. Is the name of the producer. But he wants to give an idea that his feet are on the land. And the land is Vignaiolo d'Abruzzo, wine producers of Abruzzo. So even that is so significant. I don't want to take too much time, because I was joking with Umberto and saying, how many days can we speak today on these topics? But even the European Court of Justice, in two very famous rulings, one of 1992, so just in the same time of the PDO and PGI regulation, and another in 2000, recognized that it is possible to recognize geographical indication even if not recognized by the state. And we go back to your last point, the public or the private side. And recognize that was a case of the Torron di Alicante, which is a famous Torron. And it said such names, this is the conclusion, may nevertheless enjoy high reputation and constitute for producers established in the places to which they refer an essential means of attracting customers. So you see again, you have not only as a matter of legal architecture, but as a matter, it was declared by the Court of Justice, that this relation between the group of producers, the land, the rent, the possibility to stay there, and the use of the name is something which has been recognized at the highest level possible. And another very significant decision, this is the decision regarding a famous red wine made in Spain. The region is Rioja, and the discussion was, is legal, according to the rules on the internal market, the European free market, a state rule that establishes that PDO wine, Rioja, must be bottled within the region of production, or is this against the free trade? And the answer of the court was, this is against the free trade, in fact, but this is one limitation which can be justified because, and this is the other point significant, because if you work under the responsibility of the totality of producers themselves who have a fundamental interest in preserving the reputation. So you have another significant point, a very strong relation between the legal regime and the owner. I will not use the word owner, but just to intend, the people who is benefiting from the denomination and so is interested to maintain the highest level. So this is not only a matter of public control, it is a matter of control of the community. The community of producers is entitled to protect the community, because if I do something wrong with Rioja, you, which are my competitor, you say, Mr. Albisini is joking, he's not selling through Rioja, and so you are the first one in charge with reference to me. So what happens with trademarks and GI? You opened a very large brackets and even on that. But what is the point? This double system of sign we had also in very old time. This is not something that we discovered only in 1992 or with the French law on the la personne d'origine contrôlée. Even in Roman times, if you go in Ostia Antica, you will find signs which in some cases are trademarks of the producers, in other cases are marks of origin, and in other cases are some sort of collective quality certification marks. So this problem of having some sign which are peculiar individual sign or collective or declaring quality is part of the story. Of course, we lost it during the Middle Age, we rediscovered later, but we had already at that time. So, origin of food. And what is the meaning of origin of food? We had some meeting, we had some seminars, and someone says this is the origin of food, and we have a definition finally only in the new regulation of 2011, so very new one, on the labeling of food where there is a definition of origin. But in fact, it is a definition of origin which is taken by the code, the custom code. So it's not an original one. But what is important to accept is that even origin of food is a matter of stipulation. We have a lot of discussion nowadays, for example, in Italy, on the origin of pasta. Can we call Italian pasta a pasta which is made with Canadian durum wheat or not? Which gives the component or the way or the know-how? This is part of a stipulation. And we go back. I spent some time discussing on quality. Now I just want to go back to terroir. There is this definition which is really significant in this old communication of 1988. So it is before the first regulation on PDO. And this is a very, I think, is a very nice picture when they say that l'espace rural is a tissue. A tissue is something which is made of many different parts working together, including a variety of different activities. So not only agriculture, but even many other points. So we go back very, very fast, and a few minutes still, to the two main regulations in Europe regarding PDO and PGI. The first one, this has been the first one introduced in 1992, Regulation 2081. What is the legal basis? The legal basis is common agricultural policy. So is the land. And what is the goals? is improving the incomes of farmers and retaining the rural population in these areas. So something which is really very similar, very near to the general goals that your policy with the native Indians had. And secondly, even consumers are mentioned in the attendue of this regulation, because the consumers need information, and so consumers must, in order to be able to make the best choice, be given clear and succinct information. So the idea at the beginning of PDO was to find a way which is fast, short, with few words, giving information on the consumer, with the goal to maintaining the population and giving enough rent. So now a comparison on the definitions. What is the destination of origin? The name of origin, with its inherent natural and human factors. Of course, I beg your pardon, because it's something which is very, how to say, common for you, but maybe for students could be usual. But the same definition is for geographical indication, which is some difference. But what happened a few years ago? A few years ago, we had a new regulation. First of all, it is the so-called quality package. It is no more only a regulation on PDO and PGI, but is more generally a regulation on quality package. For example, products from mountain, products from farms, and so on, and even national definition of quality. But secondly, two things changed in a very significant way. The legal basis. The legal basis is still Common Agricultural Policy, Article 43, but it is a double legal basis. It is industrial property. So even industrial lawyers, and not only agricultural lawyers, found their way to work together. It has two legs nowadays, and nowadays it is recognized. And secondly, we find here together two things. Union farmers and producers have kept traditions alive while taking into account the development of new production methods and materials. So innovation and tradition and farmers work together, stay together. And there is the consciousness of the European legislators 20 years after the first regulation, that it is not only a matter of a common agricultural policy and land, it is also a matter of intellectual property and even of creating, designing, sketching new forms of intellectual property. Citizen and consumer, on the other side, diversity, specific characteristic, and what I wanted to stress to you, because it's been not so much noticed up to date, even the definition of PDO and PGI changed. The old definition is the name of origin. Now is the name which identifies a product. So, for example, you can have even the case of ice cider without any name of a geographical zone. And I was telling to our friends some minutes ago that we had a case very significant in Italy. I followed personally as a consultant, which is a salami, which is called finocchiona. Did you ever heard about it? No, you must try it. You should. No, sorry, I'm so sorry. You know, it is against safety food rules. I can violate. But finocchiona, as I imagine most of you know, is a salami made with finocchio fenzel, and is made in Tuscany. But this is not aceto balsamico di Modena, with the geographical name. It is not prosciutto di Parma. This is finocchiona, because finocchiona evokes not only the use of that ingredients, fence, but even the geographical area, Tuscany. And so in that case, you can have the capacity of a name which incorporates in itself a region, even without spending that name, which is not so easy to consider. We had a first example some years ago on the case of feta. You don't have Greek feta, you have feta, that evokes Greece. But nowadays we have this, and on the basis of this experience of the previous years, the new regulation recognized that, and of course insists even on inherent natural and human factor. Both are working together. The same is for geographic education. So there is another problem. I just don't want to open such a large discussion. But what is the relation? It is a friendship or is a war between trademarks and geographical indication? It's not easy. We have some rules. Usually the existing European rules apply the traditional rules of industrial property, prior in tempore potium iure, who arrives first stays better. But this is not, I go fast and I go back on this. We had some cases of the Italian antitrust authority and so on. I don't want to spend, this is the case of the Finocchiona that I told you, but I just wanted to give you a couple of cases. This one is a famous one, Calvados, you know very well, and Ferlados. Ferlados is a liqueur made in Finland, and think about your French friends when they heard about Ferlados, made in the city which is named Ferla. So they say, but we are doing things in Ferla, but the Court of Justice didn't accept this position. And the second is Toscoro. I assisted for this case before the WAMI and then before the Court of Justice, the Italian Consortium of Producers of Toscano, because an Italian very intelligent and brilliant man living in Monte Carlo decided to register the trademark Toscoro. And he said it has nothing to do with Toscano. It has to do with the Tosca, the opera from Verdi. But of course, he lost the case. But what is most interesting is this. We have a struggle on the idea which is on the basis, because you were quite exactly insisting on the history, but it's not only history, it's common tradition. And I will stress the word common more than tradition. Maybe even something new, but it's something which is common. While trademark is, of course, as everybody knows. But so, what is the level? PDO and PGI have no owner in a technical sense. And you were speaking, but the state of Quebec, the imperialistic state of Quebec, is the owner of our name. No, it's not the owner. It's the subject under the public duty to protect, which is not meeting, which is the owner. So this is the same for the example of the Italian consortia, which are the Gruppo Interprofessionnel de Protection, and they are under the duty to protect, and of course they can go in court. They are entitled to go in court, as I have done for the Consortium of Oil Toscano, but they have not the right to sell that name. They are just in charge to protect that name and also to market the name and so on. And this introduced a very new thing, which is a very interesting one. Consortia are private organizations, but they may ask the payment of a fee to anybody who uses the name. Because if you want to use the name, you need no license, of course. If you decide to produce a wine, Soave, Valpolicella, and so on, it is not under the duty to be a member of the consortium. It is, you have the duty to respect the bylaws, to respect the rules regarding that. But if the consortium of Valpolicella promotes the sale of Valpolicella or goes in court against traders which do not respect, in that case you have to pay something. So you have private bodies which are performing public function, which is a very interesting point regarding administrative law. And cases of this, they go before the administrative court and not before the ordinary civil tribunal. And so I'm going to the end of this, and I apologize for the time. We had some very interesting cases, not regarding conflict between trademark and PDO or PGI, but conflicts between trademarks which evolved in putting some ideas we can use very, very in significant way in the area of geographical indication. And this is the problem of bad faith. We had some cases, two cases, famous, decided in Europe. One of 2009 and the other of 2013. The first one regards Schokoladefabrik Lindt, and the second one, the Salini Costruttori. Salini Costruttori is a very large building group in Italy, which builds up airports, motorways, bridges, harbors, and so on. And they didn't register their trademark, their name as a trademark. But they use it wherever you go. If you go in the motorway, you will see Salini Costruzioni there. Or if you go in Africa or South America or in Suez or the new Panama Channel, you will see Salini Costruzioni. And another company which worked with them decided to register the trademark Salini Group, and before the Office for Trademarks in the European Office for Trademark. Salini Costruzioni went against them, and the court accepted this opposition, said that that registration was made in bad faith because the subject who registered the trade name should know in advance that that name has been largely used in the past. So, if we go back to a discussion which has been very strong during this year regarding the common property of Indians, I mean Indians from India, or other population in other regions which use plants or other herbal remedies for medicine, so on, the so-called traditional medicine, with some specific name, and some very large international company registered their trademarks, I think you can go against this registration. And the same, if there is someone, did you try the blackberry sauce? Did you? No, you had no courage. But if, you know, in the traditional world of First Nation is known something which is called blackcurrant sauce and so on, even if I come here, I am not entitled to register that. This is a very important tool. So what is the final consideration? We had other agreements and so on. But I think that in this case, just we can catch from this experience in many different areas of food law as an experience of true competition. So we are not asking to have a protection of the weak, but we are asking to have a fair competition, even against people who are trying to use in their advantage these rules. When you look to these rules in a very new, effective, creative way, you can find even intellectual property laws regarding trademarks, many significant tools to protect this. I think this is the final task for legal scholars. Thank you for your attention. Sorry for the time.
So, thank you both, the speakers, Professor Moise and Professor Albisini. I took a lot of notes, so I'm not used to taking so many notes, so it's a sign of interest they raised in my mind.
He knows that there is an examination later.
Yeah,
so
yes, examination never ends. So, but I mean, I would rather ask you if you have any question, I mean, the students, because I think you are the primary audience for this seminar, and we're very glad to hear some voices for the audience about what you heard and your impression. Any comment, question? Don't be shy. And I mean, English is welcome, but if you prefer to speak in Italian, we can arrange some translation.
Or German, if you prefer Deutsch.
German, French, and so we are trying to manage different languages.
Loud silence.
So, I don't know, I mean, I can start myself if you prefer. Because, I mean, it's not by joke, I was really taking a lot of notes. And I think there were also some common points and I had some critical thoughts when I was listening to your presentation. One, for example, was about the relationship between GIs, tradition, and market. Because I think, and maybe it's a problem for First Nation, here we have a classic case of commodification of tradition. So once you create a geographic indication, you are basically making a commodity out of tradition. And indeed, I mean, going back to your point, terroir is more product-centered than territory-centered or place-centered. So it's about it's about a product, not a place. Why? I think it's because you sell a product in the market. You don't sell a place in the market. So in some sense, I think there is a sort of bending of this in order to make this system working in a market, to commodify the market. So I don't know, I would like to have your impression, and if this is a problem for First Nation, because I think, as you were saying, place is not just about products, it's not just about, it's a part of the spirit of a nation. Maybe false guys, we studied in comparative law, so maybe this is going to create some tension within the First Nation communities. I mean, also for you, the question.
I first must say that I concur to pretty much everything that my colleague said, and I think I've found a new friend in Fernandino. For me, just let me go back. The geographical indication is a fantastic conceptual object. This is, and I agree, I would go as far as to say that law is technology. Because, and geographical indication is exactly this. It has been a conceptual innovation. Another point that I like to stress is what fascinates me, since I've been interested in the topic, is the power of imagination that geographical indication requires. It's a place where you recreate, when you collectively dream. And that is very, very important. And there's a direct tie with First Nation and oral history. You need to have a story. And Eyesider is exactly this. It's allowing a group of producers, a group of human individuals who truly believe in their product, which is more than a product, which is their soil, it's their terroir, that's the family-owned place, and they reinvented. Through the brand, through the design, they really capture the collective imagination. So that I really find this fabulous. A point now to your question, Matteo. I think there is the First Nation and Christian Coucou I met had a very clear idea. He had a sense of there is a positive outcome of geographical indication, but is there also something that reminds them of the colonial and the colonial relationship, especially in common law, the relation between the federal state and the First Nation. For those who know a little bit, is the state as the crown, as we call it, as a fiduciary duty to the First Nations, meaning that the land itself is not and never owned by First Nation. And by various trick and circumvented relations, Westerners managed to compromise and say, this is yours, the state of white people will take care of it for you, right? So, and if you think about it, they quickly realize that there is something of that sort with geographical indication, because there is a surrendering of their right to the state, who will be the state of Quebec, who will not own the geographical indication or the designations or the reserved claim, as we call it in Quebec, but will, in a sense, administratively regulate it. And they pretty much know, because they deal with the Quebec administration and the Canadian administration, that even if it's not in the text, there is a surrendering of power over a sign. That means they could be told one day that this family is not doing the blueberry sauce as per the regulation, which has been notified in a ministerial regulation that has been published at the official Gazette of Quebec. And that is something they're very conscious of. And so they're not there yet in their relationship with the state. So it has sort of a bad taste, just the fact, and I think it's a beautiful thing, that the state is now engaged. It's not just private litigation will carry the cost of protecting these names, but it has a sort of a negative ring still, because of the relationship they will have to entertain with the state of Quebec. Hence, certain reflection about having a sui generis, so a second level of sui generis system for First Nations that will give them full jurisdictions over their own cultural expression through name.
All the questions which have been raised today are really interesting. Going back to your first question, are we speaking about a product or are we speaking about a territory or a terroir? Because you are not selling a territory. And I just want to remember two small stories. One is Italo Calvino. And Italo Calvino, which everybody I think knows here, wrote about a territory which is being eaten. So when we eat something, and just speaking about us, which we come from the south of Italy, when we speak about burrata, we think to Puglia, for example. So we are eating a territory. But the second one, I was in France in 1999 when I was just starting to study these things in an international meeting by the winemakers in France, and they were saying a terroir which is exported. But if it is land, and so you can't export. But in fact, you are exporting the idea of land with that. So it is a very strict relation between the products and the land. And of course, the idea, as we have seen in these decisions of the Court of Justice, and also in the premises of the European regulation, is not a land as a matter of earth, but is land with inhabitants, with the community. And this is the second point. I'm going back to your consideration. And traditionally, certification trademarks or, collective trademarks have an ownership, so they are of someone. The matter was that in the first, say, 15 or 20 years, the consideration of PDO and PGIs in European legal culture has been something very near to collective trademarks. And so the answer was the public officers, they were not under duty to go against this. And that created big problems, because the beneficiaries of a name, in most cases, they did not have enough resources. And the example which I was always doing to my students is, if you have a garage and you pay to the municipality to have something which says a private car cannot stop before my garage, and I pay something to the community, but when they come before me, I just phone to the local police, not in Rome because we have no local police, but in Trento, for example, and the local police is under duty because they are giving to me this right. And this has been recognized for the first time in the new regulation, the new quality package in 2012. So all the public bodies are under duty to act ex officio with no cost for the producers. On the other side, this has not the meaning that the single organized producers are not entitled. They can go also in court if they want. This is two sorts of protection, private protection and public protection. And moreover, which is also more important, what is the role of the community? You were speaking about the Indians. And what is the role of the bylaws? This is another problem which has been longly discussed in Italy, because if you have an innovators, we had a famous case with Parmigiano Reggiano. There was an old man, Mr. Biraghi, who said, I am doing the best Parmigiano Reggiano. The receipt of the consorzio is a bad one, is an old one. I have technical, which is much more innovative. You are free to do this, but you cannot use that name, Parmigiano Reggiano. You can sell blackberry sauce, but not with the name of the Indian community. For a second part of the consideration, because when we are speaking about food and products and market, we are speaking about producers, Indian community or farmers Europe. But on the other side, we are speaking about consumers. And the consumers wants to know what is buying. He wants to know their identity. So if you have some bylaws saying that when you produce Parmigiano Reggiano, use this technique and not this other technique, also if it is an innovative technique, you are guaranteeing the other producers, but you are also guaranteeing the consumers. Otherwise, the consumers are not guaranteed. But on the other side, we have a very detailed system for first proposal and second modification of the bylaws. As a matter of principle, only collective groups may propose for the recognition and may propose for the modification of the bylaws. I give you just a couple of examples regarding wine. Everybody knows and drinks, I imagine, Chianti Classico, which is a very famous red wine from Tuscany. Until 10 years ago, it was admitted to have until 15% of white grapes within the red Chianti Classico. You can't imagine. Why that? Because when the Chianti Classico has been recognized for the first time, the farmers were poor. So they didn't have enough money to change all the grapes in the red one, Sangiovese, Merlot, and so on. And so they used also white grapes. Later on, they wanted to have a more sophisticated product. And so they decided, and they asked, and with a long way. So it is true that there is a role of the public authority. But the legitimacy to start the proceeding, to recognize and modify, is always to the community. So this is another matter of identity. So if we speak, there is another Article 22 of the French Code speaks about le territoire. I hope that you will, I apologize for my French, but lorsqu'un territoire présente une cohésion géographique, culturelle, économique ou sociale, il peut être reconnu à l'initiative des communes ou de leur groupement comme ayant vocation à former un pays. Et il pays is entitled to have something which is a sort of drapeau. It is entitled to have a sign, a flag of the pays. And so, but the initiative, I think that the French worked a lot on this. So, la charte du pays, it is only the declaration, the visual declaration of this pays, and of course, in charge is the pays. And this is very important. It is after, but of course, it is always a matter of, compromise among public and private.
All right. Pierre, I have a question for, you talk about the legal transplants occurred from France. So I would like to know which were the determinants of these legal transplants in terms, because hearing your story, it seems to me that at the very beginning the story of GI in Canada was very unsuccessful, or at the very beginning. So somehow you were striving for having this new legal tools accept in the territories and seeing the possibility of exploitability. But before that, you had a legal innovation. I mean, official gazette and so on. So which were the determinants? I can easily guess has to do with the roots, the French roots of Quebecians, declaring a sort of French unicity of the legal tools, in nesting this legal tools in the Canadian or in. So my question is, the political determinants of these transplants has to do with something that has to do more generally with a political connection or a social-linguistic connection, or has to do with the idea that this tool could be effectively used in order to spin and to push forward the agriculture in Quebec. So the symbolism of the legal transplant. That's my question, and then I have a second question.
Thank you, Umberto. For me, especially as because I'm French originally, so I really saw it. I think there are many explanations. The first one is the reflection and Quebec tourism started to pick up in the 80s, and it is the waves of tourists coming in and who have actually recognized, identified places and products that were taken for granted by Quebecers, but who had a far broader meaning. And in fact, it is the tourism who helped signaling places, products that were in fact not as common. So it's interesting. We say love is in the eyes of the beholder. This is exactly the case. It's in the eyes of the people who are slowly visiting, who came, the Americans, the French, the Italians, the Europeans coming, the English coming and say, well, this is very special. And then so there a slow process which has to do with the coming to age of tourism, culture, and the overall the different waves of immigration as well. So the 30s where the Italians came, and then the French, and then so they all brought something special. So the level of awareness about speciality and traditions became to be owned by Quebecers, and they became also, and that's a second point, which is a story of the ice cider of Quebec. The producers and Quebecers were always there was an inferiority complex vis-à-vis the land, vis-à-vis a shared history between the English and the French. It's almost like they were the third generation, the byproducts of huge imperialistic countries. So it came through the referendums, through the independence. The two waves of referendums in Quebec, as you know, had left the country quite divided. But it also a significant marker by asserting identity. Then we came to realize that identity is also through what you eat, through what you drink, through what you're able to do. And so that came. So if you see the date, 1996, 1995 was the referendum. So it came as a proclamation. We were proclaiming, and part of being an independent state is to have markers. And that's how it came about. Unfortunately, and you said it exactly, I think we were overestimating the importance of law in something that is, again, bottom up, that it has to come from the community. So it's not because it is in the text that it works, and we were ill-equipped at the time to have it developed.
And my second question has to do, as with Ferdinando, is this: what are the chances that you see in the near future, or even not in the near future, but the path in the future, to have a GI recognized outside the boundary of a similar family as the French and Quebec? I mean, they were in dialogue before, and there were strong political reasons for, you just said, for this transplant. So what in your experience, in your sense of the future, are the chances that GIs may be circulating as a global tool, having countries that do not belong to the tradition that was able to create this new tool, seeing the convenience, seeing the if you want also the marketing power of this legal tool that is so unique of the Roman, civilian and European now legal world.
You know, Umberto, your question is a typical question, a typical question from a comparative point of view, and my answer is yes, is a strong yes. And traditionally, scholars studying international law, they were interested to these topics, and we had a list of international agreements protecting PDO and PGIs. In my presentation at the end, there is a list of treaties and so on. But the significant process, in my opinion, is not only that, but is more the legal transplant. And I prefer not to use this expression, but is this process of circulating ideas. So we must go back for a little. And the European regulation of 1992 was, in my idea, an answer to globalization. And the main reason was exactly the same that you mentioned for Quebec. The reason was to maintain identity, and at that time globalization meant European community. Because we had the decision of the Court of Justice in the 70s, in the 80s, Cassis de Dijon, so on, Italian pasta, German beer, and so on. And the idea was not only that products could circulate, but also names could circulate without having a label specific. So in Germany you have been allowed to sell beer which was not made according to the traditional German receipt, or in Italy Vanguard which was not made, or in France and so on. And in that case, we all, as European members of the community, we borrowed the model from France. Because I must admit that there was in France this system of appellation d'origine contrôlée, which we didn't have even in Italy. In Italy we had a lot of products protected, but with specific decrees or law. We had a decree for Parmigiano Reggiano, we had a decree for Prosciutto di Parma, but we didn't have a general law. And when it has been approved for the first time, it came from something which has been proposed by French politicians as an answer to globalization. And in fact, at the beginning, many, even in Italy, did not appreciate really how this was a very new. They didn't pay attention. It was a slow process. Nowadays, Italy is the country in Europe with the highest number of PDO and PGIs. But at that time, that was not so clear. So that was the idea. So in fact, you can say, Umberto, that at that time, we borrowed in all the European community an idea, a legal model, which was a typical French model. What is happening today? That, in fact, we had an experience. I just must take a couple of minutes. We admitted, starting from the first regulation, the registration in Europe, even of foreign, I mean not European, PDO and PGI, under a condition that even the foreign countries admitted European PDO and PGIs by them. That condition, as we know, has been declared invalid and illegal by the WTO panel. So the European regulation has been modified, and nowadays you can register a PDO or PGI from China, from India, from any other country, from Antigua and so on, even if European PDO and PGIs are not recognized that. But which was the result? Most of these countries have introduced their own rules regarding PDO and PGIs, not on the basis of an international agreement, but through their own way. So, for example, Turkey has introduced a Turkish law many years ago on PDO and PGIs, not only regarding food, but even other products of the local artisanal. And I had a very significant case regarding the basmati rice, and Thailand introduced their own law on PDO and PGIs. So we have this phenomenon, which is this phenomenon of mutual implementation. China introduced a first law 2 years ago, which is not, how to say, a photocopy of the European, but in fact recognizing PDO and PGIs and is working on this. So many countries are working on this through a way which is not the traditional way of international agreements. We, of course, we have the agreement with Canada and so on, the agreement with Australia and so regarding wines and so on. But what is interesting is that this model has been appreciated for its basic identity elements, the reference to some sort of collective goods which are expressed by collective local communities and which is expressing a deep roots in the land and in the community living there. So I think this is a success story. We can be very proud of it.
I would simply add this is a beautiful idea because it's the local in the global, and it's an easy sell even for people who don't buy and don't get. So first of all, we've been forced, as you know, through the CETA agreement to recognize many of your products, but it's making slowly its way. And it also, there's a past the fact that you create and that the idea is traveling has a huge impact. So since 1996, Quebec is getting active and all excited, and all the rest of the provinces are just looking. Quebec is what are they doing? So it's starting now at picking a little bit pace, and the result of that it has created an healthy competition between provinces, between them, and also between provinces and provincial governments and the federal government. Because the federal, it's a strange dynamic, because the federal government is in charge of the international treaty. So and we don't recognize geographical indication, but for wines, and now with the list of food products through the CETA agreement, but there is no conceptual validation of that. It's really by a few provisions in the Trademark Act, and you feel the resistance within the text between the two models, right? But so you have this, and Quebec is bypassing completely. So we're not too sure now if at one point Quebec will deal directly with Italy or France by having bilateral agreements without the consent of the federal government. So it has had a huge influence. So the evidence of that is that Ontario has started to adopt a similar legislation, and this year the BC, British Columbia legislation, and what they like in British Columbia is the quality aspect of it, so the certification part of it, because they are green, bio, and all of that. So and they have adopted, without telling us, but they used the European/Quebec model, and they used it and they revamped it to their own interest, and they have now a beautiful piece of legislation that they're using mostly for bio food, but not just bio, but they can actually derive all kind of science and labelization through the law that we know. So it's a beautiful concept that is, again, this idea of local, being national in a global world is an easy sell an easy pitch for many.
So just to probably close our meeting, if we stipulate that GI are a sort of food feuds, going back to the idea of the territory and the town, the feuds. So we may go back to Holmes' one and paraphrasing Holmes' one, the invention of tradition. We may say the reufidalization of globalization. I mean the idea that this tool will spread in the globalized world. It's peculiar because in a sense gives the sense of as you said, the global and the local. Walking together in uncertain future.
You just can add that it's typical of this experience of today of globalization, that we are looking more and more to models, legal models, and importing them. I will add to the Quebec the experience in California. And, winemakers in California, for a long time, they were just trying to take the repetition of European, French, or Italian wines. Nowadays, they are proud of their own names, and I know that they are preparing now a state law on PDO and PGI regarding wines. So this experience is trying to find some answers in a global world to problems which are common, and then look to this. And we have many other experiences. We can speak also about the system of control. You mentioned the idea that there is a guarantee that the product is respected and so on. And we have this experience in Europe that we are speaking about globalization of control. We have a new regulation on this, on the cooperation among authorities. I see as the next step, as we got after more than 20 years, the so-called protection ex officio all over Europe, which traditionally we didn't have, because we had protection only in the country of production. In the other countries, you just had to use private protection. Nowadays, you have public. The idea that you can get some sort of involvement of authorities in other states which are not members of the European Union, and even outside the WTO. Because, in fact, WTO, I tell to the students, just for remember, it was in the same year, 1992, that the TRIPS, the trade-related industrial property rights, recognized protection to PDO and PGIs, but only if it was used in a way which can create a fraud to the consumer. So you can produce Parmigiano Reggiano made in Texas, because in that case there was no fraud for the consumer. This is not admissible today, and the way is that passing these models and sharing these models with this very complicated mixture of civil law and common law concept. It is just a matter for comparative lawyers.
Okay, so I think we have to conclude. So since globalization has been evoked, I think we experienced some positive effect of globalization, transatlantic dialogue, and I think we have to thank both the speakers for this dialogue. So thanks again to both of them.
Thank you.